does apply to them, and they'll have to make sure that folks have a certain status if they, in order to reside at the complex. I hope that answers that question.
Thank you, Kim.
Thanks. Could you also talk a little bit about under the CARES Act, how that affects everyone, including immigrants?
So the CARES Act, in terms of, the CARES Act was passed on, I believe, March 27th. That's also known as the Coronavirus Aid and Relief Economic and Security Act. And that act, with respect to the landlord-tenant context, prevents landlords who are subject to the act from issuing notices to vacate or filing evictions, and we'll get to that process later on to the presentation, but they can't even issue notices to vacate until July 25th. So there was a 120-day moratorium to prevent landlords from filing evictions against persons who are residing in properties that are subject to the act. This act is extremely broad. So if a property receives any sort of federal housing subsidy, they're subject to the act. If the property also has a federally backed mortgage, they're subject to the act. So again, they can't even give a notice to vacate to a tenant until July 25th, and that notice to vacate is 30 days, which is longer than what's the the Texas Property Code. Typically, a notice of vacate only has to be 3 days, subject to the lease. So that extends it dramatically. And again, it doesn't matter what your immigrant status is under the CARES Act. If you're residing in that property, then it applies to you, those protections.
Thanks, Kim. And how about under the state of Texas? Are there any protections here?
So under the so with respect to locally, the state, when the coronavirus situation started back in March, there was a moratorium locally in terms of that applied to every jurisdiction within the state of Texas. Under the Supreme Court, there was an order to stop any eviction or any proceeding that was relating to evictions. However, that ended on last Monday, on May 18th. Locally in Harris County, we have 16 justice courts. Those justice courts have exclusive jurisdiction or authority to hear evictions. There are some justice courts that will not hear evictions until after June 1st. So the way what that's going to do is extend the time out a little bit for folks not only having their eviction heard, but also the writ of possession. That's the procedure that actually allows a landlord via a constable to actually force a person to physically leave a tenancy. That will be pushed back as well till at least after June 7th, because a writ of possession can't be issued until at least 6 days after the issuance. After the entry of a judgment, an eviction judgment. And again, that's dependent upon if the person, loses in court and there's a judgment filed against them, then and only then can a person be forced out of their home legally. And there's no one who is exempt from that judicial process subject to evictions. Doesn't matter what your immigrant status is, a landlord has to go through and judicially evict you and get a judgment against you. And then if you don't appeal that judgment, which John Ross will go over in a few minutes, then and only then can they get a writ of possession, and the writ of possession has to be served on you by a constable. You get a certain period of time, about 24 hours after it's served. So that process, again, is how that has to work no matter your status.
I just wanted to add, even the Supreme Court issued order number 17 today, which really kind of outlines how the court should be handling hearings in person. And I think it pushes back jury trials until at least August. And there's some exceptions, but this is kind of just a reminder, an ever-changing type thing. And I think the courts in Texas are still figuring out what they're going to do. But yeah, I just wanted to mention that I think the Texas Supreme Court issued a new order, just today.
Yes, just today. Great point, John Ross. So folks should, and we can send that to you, Andrea, and then you can disseminate it appropriately. But yes, folks should review that in order to help their clientele be able to understand what they can expect with this in this COVID environment. Via obviously, many courts are going to be doing trials by Zoom, and there's certain procedures that had to be abided by with respect to that, and that's all new and different, including for attorneys. So folks should be aware of those changes. Thanks, John Ross. Okay, and this is with respect to the CARES Act, with this in terms of how do you know if your property is subject to the CARES Act? Well, like I mentioned, if a person is receiving any sort of federal subsidy, then their property is going to be subject to the CARES Act. However, I know many people were wondering if it will indicate that on their lease. It probably won't. What they'll have to do is, and we'll send some materials to Andrea later to disseminate, is there have been, just within the last several weeks, a couple of databases that have been established in order to where they've been compiling properties so that folks can search online with respect to whether their property is subject to the CARES Act. And a couple of these databases, you can type in your address or the name of the apartment complex, and it may pop up. But again, there's no need to even do that if you know you're receiving a subsidy of some sort. Additionally, what landlords are now required to do in a Supreme Court order that was issued a couple of weeks ago is that when they file the eviction, they actually have to sign an affidavit swearing under oath to the court that they know that their property is not subject to the CARES Act. Now, some landlords, intentionally or unintentionally, may falsify the affidavit where their property is subject to the CARES Act and they indicate that it's not. So it's best to consult with, if you really cannot, if you know you're not receiving a subsidy, you can search the local property records where you live and determine whether there's a federal mortgage subject to the property. Or like I said, the best resources are these databases. The National Low Income Housing Coalition has a great database, and Texas Housers, in coalition with FASTA and Texas Rio Grande Legal Aid, they just developed a database as well. Lone Star Legal Aid is developing one that their staff will be using to help their clients. So that's the best way. It's harder to do it if you don't have access to internet. To be honest, you may want to visit your local, to the extent that that a local library is available to you. You may want to be able to research there.
Yeah, and we'll be talking a little bit later about some local resources, including internet. And then if folks, for those of you who work with clients who may not have internet, once you have these resources, you can with those searches.
So the next question is, what are tenants' rights when the landlord charges late fees for non-payment of rent?
Yeah, so hi, I'm John Ross. I'm a managing attorney with the Housing and Consumer Unit at Lone Star Legal Aid. I saw some questions in the chat, and so we're going to talk about the eviction process, but let's just answer this question real quick. One of the first things that you should do is see if your property or your landlord's covered by the CARES Act. If it is, that gives you a lot of the protections. And so the eviction process is going to be a little different for you. The CARES Act, another benefit is that the landlord should not be charging any of the fees, no late fees, until July 25th. So theoretically, until you're late on your August rent, there shouldn't be any late fees charged. There's some dispute about whether they can start charging them on August in the back rent. But my position is that there should be no late fee charges if your property is covered by the CARES Act until July 25th. If your property isn't covered by the CARES Act, you need to look at your written lease. The lease is going to cover how much your landlord is going to be able to charge. And so there is something that a landlord can charge unreasonable fees, and something about if it's above 10% of your monthly rent, it wouldn't be considered reasonable. And there are some other factors to consider. You know, the unfortunate thing is probably you have to take your landlord to court, and the damages are $100 plus 3 times the amount that they illegally charged you in attorney's fees. So there is a mechanism for you to challenge if a landlord's charging unreasonable late fees. And so, yeah, now we'll go over, the broad step of the eviction process. So in order to start the eviction process, first, the tenant has to breach the lease somehow. Typically, the way that happens is non-payment of rent. So if the tenant does not pay the rent, that's a breach of the lease. The landlord then has to terminate the lease by giving what's called a notice to vacate. The notice to vacate is basically a letter that states that they need to vacate the premises because of the breach of the lease. Typically in Texas, again, you need to look at your written lease, but typically in Texas, there's going to be a 3-day notice to vacate. In some instances, that can be as long as 30 days. If your lease term ends, you go to a month-by-month basis, and then to terminate that lease, they need to give 30 days. Again, under the CARES Act, they need to give a 30-day notice to vacate. But typically, what all this eviction process was before COVID-19 happened was that they need to give that 3 days notice to vacate. If during that 3 days notice, the tenant does not leave, the next step is the landlord's going to file an eviction. Once the landlord files an eviction, the petition gets sent off and the tenant's going to get served by a constable. If the constable can't serve them or is unable to find them, then they usually have to ask the judge to serve them in a different way. Typically on this process may take 2 weeks. When you get served, you're going to get notice of when your eviction hearing is. It's very important that you show up to your eviction hearing. Again, like Kim said, all of these cases originate in the Justice of the Peace Court, which are basically small claims courts around Texas. Once you get that hearing date, you're going to be in front of the JP and you're going to get your opportunity to explain to the judge what happens. Then the judge is going to rule. The judge can either rule for you, which would be good, or can rule for the tenant. And if they rule for the tenant, then the landlord has to start this process over again by giving a notice to vacate and all of that. However, if the landlord wins, the tenant has 5 days in which to appeal. Typically, when you appeal, you have to pay a bond and you have to pay 1 month's rent into the court. With our clients, and you should see with a lot of your clients, you're able to get that bond waived by filing what's called an inability to afford costs. And so all this is important. You can fill out the inability to afford costs and turn it in with your appeal. And that will act as your appeal from the Justice of the Peace Court to the county court. In the Justice of the Peace Court, after a judgment's made, you have 5 days in which you can appeal. After you appeal by turning in your inability to afford costs, you have 5 days and you have to pay your rent into the registry of the court if you were evicted for a non-payment of rent issue. During the entire appeal process, you will have to continue paying your portion of the rent into the registry of the court in order to keep your appeal alive. If at any point you fail to pay your portion of the rent, the landlord can ask for possession. So all of this is important. At the Justice of the Peace Court, if you fail to appeal in the 5 days, then the landlord can ask what's called for a writ of possession. The writ of possession basically allows the landlord to get the possession of the property. When that writ of possession is issued, a constable will come to your house and they will serve the tenant with the writ of possession. When that happens, the constable will give you 24 hours and to vacate the premises. If you do not vacate within that 24 hours or come up with some other legal alternative, then the constable will forcibly remove all of your stuff. So, this is getting, to the critical points. But luckily, you can appeal the judgment from the Justice of the Peace Court and you go to the County Court of Law. You'll get a new hearing and that setting is de novo. So what that means is that it's an entirely new trial. Whatever happened at the Justice of the Peace Court doesn't matter anymore, and you're having a new trial in front of a new judge. Again, the same kind of principles are going to apply. If the tenant wins that case, then the landlord is going to have to start the whole process, the eviction process over. If the landlord wins, then the tenant's options are getting rather limited. They're going to have to pay a bond in that case if they want to appeal, and the bond is usually set at a high amount, like $10,000. And a tenant can ask to get that, lowered, but at that point, there's a lot less options that the tenant has. Again, when you go to the county court, and if the tenant loses, the landlord can ask for writ of possession from the constable. The constable will go to the tenant's house and serve them with that writ of possession. And again, they'll have 24 hours to move after they got served with that, with that writ of possession.
So John,
so that's the eviction process. Yes.
Sorry to interrupt you there. Assuming someone doesn't have an attorney, how fast would that eviction process usually occur from the notice to vacate to the sheriff removing the belongings, assuming that the person loses the case?
Yeah, so, well, and I guess we're going to be gathering more facts. COVID is going to, I think, slow down this entire eviction process. But before COVID happened, I mean, typically, Justice of the Peace Court would be 2 to 3 weeks after they get that notice to vacate. They might get served, and they'll have their hearing in front of the Justice of the Peace Court in 2 to 3 weeks. And so, if they don't appeal, it might be 3 weeks. With the appeal process, that gives them another 2 or 3 weeks, another hearing, and extends that time. So typically, if you go through the entire, all the way up to county court, you can get 6 weeks, more or less. Again, once you go to the county court, you're going to have to pay your portion of the rent during the appeal process. But I've seen the appeal process go extended to an insane amount of time, much longer, 8 months, 10 months. And if they're paying their portion into the registry, usually they don't have a problem, and they can work with the landlord during that.
I think that's probably the concern now with COVID, is that people aren't going to be able to pay it in to the registry. But let's say before they get a notice to vacate, if they're just getting, threats of eviction, or a landlord telling them if they don't pay by a certain date that they're going to be evicted, are there some things that you guys have found that works to prevent going to court? How else can a tenant try to come to an agreement with a landlord, like a payment plan, or some other ideas to help prevent the eviction, proceeding to begin with?
Yeah, I mean, I think that's always an option, and an option I think unfortunately doesn't get there is communication. A lot of times lawyers get involved because communication breaks down. It's on both parties, but the landlord might just give the notice to vacate and the tenant doesn't know what to do. And really, instead of the landlord going and talking to the tenant and seeing what's going on, how can we help? They resolve to this legal problem, the tenant goes and resolves the legal problem. But I say, if you can get that relationship and communication, talk with your landlord. You can work out a payment plan, hopefully. There's no obligation that the landlord has to take the payment plan, but it doesn't hurt to ask. A lot of landlords, especially now, if they understand the time frame that it takes for the eviction process to work out, they are willing to forego the attorney's fees that they're going to have to pay, and the time it's going to take to work out a payment plan with the tenant. So I think those are good options. And something, like I said, they can explain the eviction process to the landlord and say, look, this is what's going to happen. It's going to take you, 4 to 6 weeks. And you're going to have to pay someone to go and do all this. Can we work something out? This is what I can do. And
especially now that they may not even find a new tenant who is able to pay rent, as easily.
And I think to that point, to John Ross's point, Andrea, sometimes it saves the landlord money, particularly with the landlord. If a person appeals, and the person can appeal pro se, Lonestar helps folks do that all the time. We provide them with pro se documents if they qualify for our services. But once they appeal to county court, then if the apartment complexes and LLC, then they will have to retain an attorney to be able to represent themselves in county court. And so that's extra money that they have to spend. Now, of course, if they win, they'd be, you know, they can add attorney's fees to that judgment. But with folks in their economic positions, they're never going to see that money. They're never going to be able to collect on that judgment. So it behooves landlords to work out a payment plan to save themselves eviction filing fees and attorney's fees later.
And then another question that we've gotten from folks is, if someone is evicted, is it going to impact their credit report? And if so, for how long?
So the filing stays, the filing, even if you win, is a public record, and it will show up for as long as 7 years. So that's the problematic part of it, is that even if a judgment is not entered against you and your case is dismissed, which happens, you know, which Lone Star helps many folks get their cases dismissed, I mean, hundreds probably a year, but the filing itself will show up on your credit report. Is there any?
Great, thank you. And we're going to shift gears now to talk a little bit about homeowners. Go ahead.
So are there any local, state, or federal help from homeowners who cannot pay their mortgage? And are there local accommodations if homeowners cannot pay local property taxes on time?
Yeah, so I would say the CARES Act actually gives a moratorium that I believe started on March 18th for 60 days for any kind of judicial or non-judicial foreclosure practice to start. And so that would have ended May 17th. But in Texas, they have to give at least 21 days notice of the foreclosure sale. So foreclosure sales aren't even going to start taking place until August for these properties covered by the CARES Act. Again, this is why it's important. You can see if your own property is covered by the CARES Act. And if it is, you can ask for a forbearance of 180 days with your servicer. And my understanding is that it's extremely simple. You just ask your servicer for this forbearance, and all you need to let them know is that you were financially impacted by COVID-19 in some way, and you would get an automatic 180-day forbearance. And the way that forbearance plays out is after the forbearance, you can get up to a year to pay off the amount that was due during that forbearance. Another option is to just put it at the end. So basically you add 3 more months to your loan and you just continue your payments from there. Once that 180 days is up, you can even ask for an additional 180 days. So that would take you to a year of forbearance opportunity. So I encourage people, they need to talk to their servicer, and their servicer will let them know what their options are. If it's not covered by CARES, you need to talk to your servicer, and a lot of other mortgage companies have options, and they have forbearance plans and modifications and other options. And if you reach out to your servicer, they'll provide you with what your options are. As far as property taxes, I haven't heard of anything specific to the pandemic, but there's always, exemptions available. I encourage people, because sometimes they don't necessarily put it on, but you put on your homestead exemption, you can get an over 65 or disability exemption. And if you have an over 65 or disability exemption, you can also get what's called a tax deferral, where you're able to defer the taxes and pay them at a later time. I also know Galveston County enters into payment plans, and you can, talk with Harris County. And I think with all that's going on, they are accommodating. I know they enter into payment plans as well. So reach out to them, and, hopefully you can talk with them, and, just paying a little bit or entering a payment plan is going to be real beneficial.
And what are tenants' rights? What are tenants' rights related to if the landlord is threatening to call ICE? So that doesn't change your status as an undocumented or documented alien or U.S. citizen, for that matter, does not change your rights to be judicially evicted in the state of Texas. The landlord has to, again, as John Ross sort of elaborated on earlier, give you the proper notice. If you're in a subsidized tenancy, you many times will be subject to multiple notices, at least two. And then the landlord has to file in JP court, win his case, get awarded a judgment. You still have the right to appeal. And even if you can't, which helps to elongate the process and give you the opportunity to argue your case again, de novo or anew in county court at law. So that does nothing to undermine the process. It should also be clarified that in neither the county court or the justice court where an eviction originates, your immigration status should not be questioned. It's not relevant to the proceeding at all. And if you are not English speaking, you should also have the right to request an interpreter so that you can understand the proceedings. I will call the court. If you don't have an attorney, your attorney will work that out for you. If you don't have an attorney, then I would call the court in advance and tell them that you need an interpreter to be available to help you be able to communicate and understand the proceedings appropriately. But yes, ICE, again, I can't speak to the immigration procedures, but it's completely separate and distinct from the eviction process.
I think that's really helpful for advocates to know, that you guys have never seen ICE at the courthouse, to know that immigration questions don't come up in these hearings. And I would assume that if someone has an attorney and that question's brought up, then there would be an objection. Also really great to know that these are available, interpreters are available in Spanish. And obviously folks would want to prevent eviction if possible. So Katie, are there any local resources that can help folks pay their rent to begin with?
Yes, there definitely are a lot of resources that are available. I say a lot. There are many sources of resources, but right now there's also a lot of need. So when resources do become available, they're definitely going quickly. To answer that question, I'd like to introduce you to a couple of resources that HILSCA's put together. First is accesshue.org, and what you can use this is a database that was created by immigrant advocates for immigrant advocates. So the services in here are known and trusted. So you can use this to search under financial assistance. You can use this to search for rent or utility assistance, and it will bring up programs that have long-running histories with providing rent and utility assistance. Like I said, some still have a little bit of buffer and some are topped out, but it's a good first place to try. I also want to introduce you to our COVID-19 resource list. And this is something that normally during an emergency, we put together a frequently asked questions from immigrants. And this, instead of taking the FAQ form, we have just made a resource list. There is a really handy table of contents, so you can scroll through these things and see what's available. There's a link to Lone Star Legal Aid, so you can get a lot of information that they were talking about today from their website. But the most important thing about these two resources, AccessU and the resource list, is that they are open source. And so the quality of the information in there is as good as you all contribute. So if you have updates, if you have additional information, even if you have questions, you can put it in there as a comment, and that'll trigger Hills to go and look for answers and let you know when the answers are there. So please feel free to use these.
Katie, sorry to interrupt.
Yeah.
There was a local Houston fund that was available if landlords signed up, and then they would make payments directly when the tenant applied. I don't know if everyone knew about that. Could you tell us a little bit about that fund and the status of it, and kind of what that tells us about the need for this money?
That was money from, it was $15 million from the city of Houston that was distributed through Baker Ripley. So there was about a week period where tenants could, or landlords could register their properties. And when it opened up to tenants to get the assistance, it went in 90 minutes, $15 million. So there's definitely a lot of need. And so I encourage you to keep your eye on what's happening, because there's more money to come. In fact, Andrea, if you want to go to the next slide, Greater Houston Community Foundation has been raising private money. And so they have immigrants of varying legal statuses as a priority population, knowing that federal money that will be coming in the future will not be available to people who are undocumented. So round 3 is expected to be announced tomorrow. From what I understand, there's 65 agencies that are going to receive money to provide rent and utility assistance. So if you have clients, well, if you have clients that, if you're with an agency that is not one of these 65 and you have clients that aren't otherwise associated with one of these 65 agencies, really the best entry into that funding is to go through 211, and they will match any individual with an agency to hopefully receive some of that funding. There's also, I'm sure you guys saw that the county voted on a $30 million fund, which will be administered in part by Greater Houston Community Foundation and in part by the Harris County Community Services Division. There are still a lot of details of this fund being worked out, how it's going to be administered. So please keep your eye out on that. Both of those websites that are up there now will have information on that. And then we'll keep updating the resource list as we find out information. Let's see. I do not know, looking at the chat box, I don't know who these agencies are, but they will be announced tomorrow and they will be posted on the Greater Houston Community Foundation, that greaterhoustonrecovery.org site. They will all be posted there.
And some of them are organizations that work directly with immigrants, including undocumented immigrants, and so they will hopefully be able to cover a large swath of Houston residents and Harris County residents.
Mm-hmm. That begs the question, would accessing housing assistance affect eligibility to obtain a green card? And Andrea is going to give us some background on public charge and how the two are connected.
Yes, and apologies for my dog who needs constant attention. So I just wanted to kind of quickly remind everyone about public charge. For those of you who have been on the last webinar we did in early May, we did an overview and I went over this, so I'll try and make it quick. But as a reminder, this is a test that's only applied when someone is either entering the United States for the first time through the Department of State with a visa, or trying to adjust their adjust their status through consular processing, for lawful permanent residents who've been out of the country for 180 days or more and are re-entering, and for people who are applying for permanent residence before USCIS. For purposes of this presentation, I'm just going to be focusing on that, but it's important to, if you hear anyone who says, I'm, going country in order to reapply, I have to do consular processing, visa with relation to lawful permanent residence, that may be a hint that they have to go through the State Department, and it may be better to speak with an attorney. The State Department has made the same rules as DHS, as the U.S. Citizenship and Immigration Services, so that makes it a little bit easier, but they aren't, it still would be best to speak with an attorney for consular processing. Generally, the public charge test is something that someone must overcome. They must show that they're not going to become a public charge in order to gain that lawful permanent residence, or their application will be denied. So There are many exemptions, so refugees, people with VAWA and U visa, so victims of certain crimes, special immigrant juveniles, asylees who've been granted asylum, those who've been refugee status, and many others. Even if they're on the path to lawful permanent residence, even if they're applying, they don't have to go through this public charge test. So it really applies to a very narrow number of people. That being said, you know, people's circumstances change every day. You marry a US resident, and maybe depending on your immigration history, that would make you available tomorrow to adjust before USCIS. So what is relevant today may not be relevant tomorrow, but that's something to consider. So when we talk about public charge, people think, oh, the use of public benefits. Well, the use of public benefits is not everything. Public charge is a totality of circumstances test. So they are looking at your age, income and assets, family status, education and skills, and your health. It's a forward-looking test, even though it now does consider the use of public benefits under income and assets, right? So it's looking at whether or not you speak English, whether or not you have a high school diploma, how old you are, right? How likely you are to be able to work, how many people are dependent on you, how many people you're dependent on. And so that's what this is trying to get at. Within public benefits, there are a very limited number of public benefits that are considered, and those are the ones on your screen right now. With regard to housing, those three at the bottom. There's not enough public housing in Houston, and certainly immigrant families of mixed status households are pretty low in number, the ones who actually are in Section 8, either, you know, voucher or project-based housing or public housing. So probably most immigrant families, even those, you know, lawful permanent residents or those in mixed status homes are unlikely to be in this, but still do consider that because they may be. And then in terms of some of these local funds that folks might be able to access for rent maintenance, while it does consider cash assistance for income maintenance in the public charge test, it doesn't consider disaster relief under the Stafford Act. And so we are still currently in a disaster under the Stafford Act due to the pandemic. And so any local cash assistance for income maintenance, for rent assistance would be fine. It would not be considered in a public charge test. And there's a link, also send out the PowerPoint for folks who want to read more about that. Katie, you talked a little bit about rent assistance, and some folks may be able to get rent, but then are concerned about having lighting or gas in their home. Is there additional assistance for utilities?
Yes, the Texas Public Utility Commission has halted all shutoffs until the governor's disaster declaration ends. So this applies to electric, water, and sewer, but not natural gas. However, CenterPoint has also stopped shutoffs. Or has stopped shutoffs. So it's a public-private effort to ensure that people are taken care of through this pandemic when everyone's employment and income is deeply affected. So the best way to go about finding out about these programs is just to contact the local utility provider and ask what kind of relief programs that they have. Also, you can ask to join the low income list. You do have to qualify for unemployment benefits in order to be on this list, which is probably fine because a lot of people without documentation don't want to be on a list anyway. And then you can also check accessu.org and see, and then call the agencies that come up to see if they still have money in their coffers to provide rental and utility assistance.
And just to jump in quickly, we didn't really cover unemployment benefits. We will on the next webinar, which is scheduled to cover employment specifically. But in order to get unemployment insurance benefits under the CARES Act, you do have to have employment authorization, both at the time that you weren't working at the time that you apply for the unemployment insurance. So if someone's undocumented, they're not going to be eligible for unemployment insurance and thus not be able to get on this low income list. And then earlier on, there was a question being able to access the internet to see if their landlord was even on the list of mortgages backed by by federal mortgage companies in order to get that extra protection under the CARES Act. Is there any assistance for folks who can't afford internet?
Yes, you can go to texaslawhelp.org, and they have a great article on internet access there. Also in March 2020, there was a whole list of providers, which you can see on the slide, that agreed not to disconnect internet or phone, to waive late fees, and to provide free hotspots. So we'll see what happens as this continues to go forward, and how long they extend these for. But right now they are in action. Also, HISD has been giving away hotspots. It's been a little foggy about how to get these. What I've been told is that you can call your child's school and ask there. I was also told by a school principal that they don't know anything about this. So it's one of there's a lot of finger pointing here, but it's another source that you can advocate for getting free Wi-Fi from.
And for clients who need legal help, like legal assistance for housing issues, if they are facing eviction, if they got that notice to vacate, what kind of support is there in our community here in Houston for folks both documented and undocumented?
Well, I hope this goes to one of the questions that was in the chat earlier. So if a landlord has unlawfully locked a client out of their home, or they've committed any other housing violations, there are there's free law help from Houston Volunteer Lawyers, from the University of Houston Clinic, and South Texas College of Law. All three of those organizations do not have any restrictions on legal status, so anyone can be helped by those organizations. Earl Carl Institute at Texas Southern University and Lone Star Legal Aid can only serve immigrants with lawful status, or who are LPRs or victims of domestic violence. So they have more limited capacity in who they can see. But if you have clients that fall into those categories, they are fantastic resources.
Thanks, Katie. And then there's also, like Katie mentioned, accesshou.org. You can find both immigration and non-immigration legal services providers. So sometimes a housing issue will flag an immigration issue. Sometimes an immigration issue will flag a housing issue. And so you want to be able to refer to both. Again, accesshou.org is a great resource for advocates who work with immigrants to look up what those resources are. And then the Immigrant Rights Hotline is for clients directly, for them themselves to call 1-833-468-4664 for referrals to providers, also information about where to access resources and other legal questions. So we have now 8 minutes for Q&A. As you guys type in some additional questions, there was an earlier question about what can people do if they're given a notice to vacate or are forced out of their homes in violation of the CARES Act. I know Katie mentioned, get an attorney, but maybe Kim or John Ross, y'all could talk a little bit about sort of like what the rights are and what happens if the CARES Act is violated.
Yeah, so the first part of the question, if you get a notice to vacate, that's basically the landlord starting that eviction process that I talked about. And again, it's just the start of the eviction process, and they have to go through the rest of it, which again, I don't know, could take like 4 to 6 weeks. If they're forced out of their home, one thing I didn't talk about is illegal lockouts. So if the landlord tried to circumvent this eviction process, there are several ways that I've seen that they've done it. They can either, change the locks or, lock you out basically, or there's something called the utility shut off. And both of those are technically illegal. The way they do them is illegal. And for the most part, I've never seen a landlord do it correctly. If you get locked out of the home, you can demand a key from your landlord and you're supposed to be allowed back in. If they still refuse, you have to go to the Justice of the Peace Court and ask for what's called a writ of reentry. You know, people have done it pro se or, you know, by themselves. And, you know, I think during this time, a lot of the JPs are willing to go out there and help individuals doing it. But, you know, you should also come and talk to an attorney if those are the issues.
Thank you. Another question we had is whether or not you guys have an infographic of the eviction process, because that would be, I guess, helpful to the person who is asking. I don't know if you do, but if you do, please do send it to me and I'll circulate that.
I don't think we have that yet. That's something that John Ross and I can pitch to our communications director, but the PowerPoint that we're going to send out, will take you step by step with respect to John Ross's presentation, and it'll be pretty clear. And the presentation actually the PowerPoint was drafted and contemplating the audience being folks who have no legal background whatsoever. So there won't be a bunch of jargon in it, or it'll just basically be a very step-by-step clear process of what has to happen. And it'll be in English and Spanish.
Great, thank you. Any other questions from folks? I was thinking, you know, in the last 5 minutes, if there's not any questions, that Katie could pull up accesshou.org and kind of show people how it works live. But I just see that there is a question. Since many of the folks coming across the southern border have Indigenous ancestry, are there any efforts to get more border tribes recognized and thus qualify for dual citizenship status? Does anyone work with Native American Rights Fund or National Congress of American Indians? I think that's probably a little bit outside the scope. I probably should have read it before I read it out loud. But I think if there's anyone on here who is working on that, please respond via the. While we have our housing experts here, I'm going to focus if there's any questions specifically on housing issues. And if there aren't in these last 5 minutes, I will turn it over to Katie to kind of show you, you know, how to drive accesshou.org, so to speak, so you can make the most of it.
Thanks.
And again, like as she pulls that up and as we wait for more questions to come in case there are any, I wanted to let you all know that we'll be having the second in the series, or third in the series if you count the first one on the overview, in June 5th, Friday, June 5th, at the same time at 2 p.m. And we will be circulating that information to you. For those of you who registered on the Eventbrite, you'll be getting all of the information that we mentioned today, the link to this recording, and the information for the webinar on employment. No other questions, so Katie, take it away.
Okay, thank you. I do want to recognize that Amy shared a link to an infographic. It looks like on eviction process. I don't know if Don Ross and Kim, you can take a look at it real quick and see if it seems like a good resource or not. But in the meantime,
Sure.
I'm sorry, have you had a chance to look?
Well, we haven't seen this yet. So I thought if you were going to open it, we can look right now.
Oh, okay. So,
Yeah. At least I haven't
Looks
seen
like
it.
that's one
John Ross.
for Dallas specifically.
Oh, okay.
Okay, so it's local.
Yeah, I'm looking over it. It's a little in depth, so it might take a while.
Okay. So
But if you guys don't have one and you want to make one for Houston, maybe that's a good starting point.
We're trying to make as many helpful documents right now. So this
Awesome.
will certainly enlighten us.
Thank you. Thank you.
Excellent. So this is Access Hue. Right now it is in emergency mode, which means that the verification process for new information that's coming in from the public is skipped. And the reason that we wanted to do that is because in emergencies, information is changing so quickly that we didn't want to become a bottleneck for information. So there's 3 ways you can search Access Hue. You can search by agency using the search bar. So if you know there's a specific agency you want to find, you can do that. If there is a program or a search term you want to find, for example, utility assistance, you can look here and it'll bring up everything that has utility assistance either in the program name or in the program description. There are also filters on this page where you can refine your search. Here you're only getting 4 results, but if you have a large number of results, you could refine it using the filters. Again, I want to emphasize that not everything here, what we've focused on is getting the primary information into any particular page. So there are a lot of data fields that were requested by immigrant advocates to help them refine how they refine the referrals they're given. And you can see all the information that's blank. So what we need you guys to do is to go in and update your agency pages and your programs so that those filters work better and people can get the most detailed information possible. So it's 2:59. I'll leave you with that very, very brief introduction and turn it back to Andrea to close us out.
Thanks so much. I didn't realize that I was stomping like an elephant on my keys without mute while I was typing some stuff. So thank you all so much for coming. We really appreciate it. I would really appreciate if you just chime in with a thumbs up, or like if you like the Q&A format, if you prefer like the traditional presenter format for what we're doing, our other sessions, as I mentioned, one on employment and one on food and nutrition, both, in this COVID era, both with a lens on immigration. Hopefully you'll chime in for those, or you'll join us for those. I really want to thank particularly Lone Star Kim and John Ross for their time, for sharing their detailed knowledge, and to remind all of you that Lone Star Legal Aid is a great partner to refer your clients for those who are lawful permanent residents, who are U.S. citizens, who maybe are victims of domestic violence. Under VAWA, they can be seen, although they have Legal Services Corporation funding, which means they aren't able to see undocumented immigrants without that tie of domestic violence. And then also on our resources, which we will share with you later, you'll see that there are several other agencies, including the law schools, UH and South Texas, that have clinics that anyone, regardless of immigration status, can go to, and Houston Volunteer Lawyers is another source as well. So again, thank you all so much. Thank you, Katie. Thank you, Kim. Thank you, John, Ross. Really appreciate everyone. And if you have any other questions, please just type them into the chat and we'll try and get to them in future webinars or via email correspondence. Thanks.
Thank you, everyone. And Andrea, if John Ross and I don't mind you disseminating our emails, so should folks have some follow-up questions, we'll send the documents that we already said we'll send to you, and you can share our emails as well. Folks just want to talk to us one-on-one.
Great. Thanks so much.
Thank you.
Yeah, thanks.
Appreciate y'all.